A jury said a coal company owed this man $50 million. The company appealed to the state's highest court. Before that appeal was heard, the company's chief executive spent about $3 million helping elect one of the justices who would decide it. Caperton asked that justice to step aside. 3 times he refused. And twice he voted to throw the verdict out. In 2009, the Supreme Court said that violated the Constitution. But it never said that justice was biased. What it said instead is stranger and more useful. And the man who won still never got his $50 million. Hugh Caperton was a coal man from Slab Fork, West Virginia, a coal town where his family had run mines. Early on, he had worked for a company called A.T. Massey. In 1993, he bought a mine of his own. The Harmon Mine, not in West Virginia, across the state line, in Buchanan County, Virginia. Remember that line. It decides how this ends. What he bought was described as a rickety skeleton. He rebuilt it. At its peak, 150 union miners worked it. Inside a year, he had quadrupled output, 1 million tons. He had a long-term contract with a Pittsburgh steel company. It was the mine's lifeline. In July of 1997, Massey bought a company called Wellmore. Wellmore sat between Harman's coal and the customer who bought it. A jury would later be asked what that meant. Caperton's answer: the coal could not get out. He stopped mining that January. Harman closed in March. The companies filed for bankruptcy. Asked later what it had cost him, Caperton said, "It's cost me everything I've got." In August of 2002, a West Virginia jury heard his case. It found Massey liable for fraudulent misrepresentation, concealment, and tortious interference. In plain English, the company lied, hid things, and deliberately wrecked a business deal. The jury awarded $50 million. 2 years later, the trial judge refused to disturb it and put on the record why. He found Massey had intentionally acted in utter disregard of Caperton's rights and had destroyed his businesses. Because after conducting cost-benefit analyses, it concluded that doing so was in its financial interest. A court found in writing that a company did the arithmetic and decided ruining him was worth it. Massey appealed to the Supreme Court of Appeals of West Virginia. And in West Virginia, those justices are elected. The next election was in 2004. Don Blankenship was Massey's chairman and chief executive. He knew the appeal was coming. He backed a lawyer named Brent Benjamin, running against a sitting justice. And here is where almost every retelling of this case goes wrong. Blankenship did not hand Brent Benjamin $3 million. To Benjamin's campaign, he gave $1,000, the legal maximum. The rest he spent himself, and the campaign had no say over any of it. Almost $2.5 million went to a political group called And for the Sake of the Kids. His money was more than 2/3 of everything it raised. He spent another $500,000 directly, mailings, letters, television, and newspaper ads. About $3 million in all, more than every other Benjamin supporter combined, and 3 times what Benjamin's own campaign spent. Benjamin won, 382,000 votes to 334,000. Hold on to that result. Both sides will use it to prove opposite things. And nobody ever alleged a deal. No bargain, no promise, nothing traded. In October of 2005, Caperton asked Justice Benjamin to step aside. The following April, Benjamin refused. He found no objective information, he said, showing he had a bias for or against any litigant, or that he had prejudged anything, or would be anything but fair and impartial. So, what does the Constitution actually require of a judge here? The Supreme Court has said plainly that most matters of judicial disqualification do not rise to a constitutional level. Almost always, whether a judge steps aside is a question of state rules, a statute, or a code of conduct. The Constitution turns up only at the outer edge. Hold that thought. In November of 2007, the West Virginia court reversed the verdict, 3-2. Justice Benjamin was one of the 3. And here is the strange part. That majority did not say Massey deserved to win. It wrote that Massey's conduct warranted the type of judgment rendered in this case. It threw the verdict out anyway, on 2 technical grounds, neither of which was about what Massey did. One dissenter called the opinion morally and legally wrong. Another warned it introduced sweeping new law that may well come back to haunt us. Caperton asked for a rehearing, and then the photographs surfaced. Justice Elliot Maynard, another of the three, had been photographed on holiday with Don Blankenship on the French Riviera while the case was pending before him. Maynard stepped aside. So did Justice Larry Starcher from the other direction over his own criticism of Blankenship. Blankenship's wealth, tactics, and friendship, Starcher wrote, had created a cancer in the affairs of this court. He urged Benjamin to go as well. Benjamin declined. And then, as acting Chief Justice, he selected the two judges who would replace the two who left. The justice accused of being unable to hear the case fairly chose the panel that would hear it again. Caperton asked a third time and brought a poll. More than 67% of West Virginians doubted Benjamin would be fair. Benjamin called it a push poll and refused again. In April of 2008, the court reversed the verdict a second time, 3-2 again. To understand what the Supreme Court did next, go back to 1927 and a village in Ohio. The mayor of that village was also its judge, trying people accused of breaking a liquor law. He was paid extra for judging out of the fines. He collected only when he convicted. The Supreme Court threw out a conviction from that court, not because the mayor was crooked. There were doubtless mayors, it said, who would not let $12 affect their judgment. The question was never that man. It was whether the arrangement would tempt an average one. 4 months after that second reversal, Benjamin wrote again. A separate opinion, defending the ruling and defending his decision to stay on it. His argument is the strongest case against everything that came next. A standard built merely on appearances, he wrote, is little more than an invitation. An invitation to supposition, innuendo, half-truths, and partisan manipulations. If you cannot show a judge was actually unfair, what are you punishing him for? On the 8th of June, 2009, the Supreme Court ruled for Hugh Caperton, 5-4. And the first thing to understand is what it refused to say. It did not say Brent Benjamin was biased. It did not say he was bought. It noted that Benjamin did undertake an extensive search for actual bias, and said that was beside the point. Due process, the court held, may sometimes bar trial by judges who have no actual bias at all, and who would do their very best to weigh the scales of justice equally. Because you cannot see inside a judge's head, and because of a problem sitting underneath the whole thing. When a judge rules on whether he himself is biased, the sole trier of fact is the one accused of bias. So, the court asked a different question, not whether he was biased, but whether the risk of bias was too high to tolerate. Whether the money actually won Benjamin the election, it said, is not the proper inquiry. And then it drew the line. Just as no man is allowed to be a judge in his own cause, similar fears arise when a man chooses the judge in his own cause. Not bought the judge, chose him. 4 justices disagreed, and they wrote twice. Chief Justice Roberts wrote for all 4, and made 2 arguments that deserve real weight. The majority kept calling it contributions, Roberts said. That is not what it was. Benjamin's campaign controlled $1,000 of it. Over the rest, it had no say at all. And Blankenship's side was not the only side spending. A group funded largely by lawyers who sue companies spent about $2 million supporting his opponent. His second argument was that nobody would know what the new rule meant. So, he wrote out the questions courts would now have to answer. He numbered them. There are 40. Number 1, how much money is too much money? The majority called it an election decided by fewer than 50,000 votes. Roberts called it a comfortable 7-point margin. Same election, same numbers, opposite stories. Justice Scalia dissented separately and shorter. The majority insisted cases like this would be rare. Scalia called that whistling past the graveyard. He warned it created uncertainty in every state that elects its judges, at least 39 by his count, in 2009. So, Caperton won, the verdict came back, and he was paid. No. The Supreme Court did not give him $50 million. It gave him a different judge. The case went back to West Virginia. That November, without Benjamin, the court ruled against him again. This time on a contract clause. The suit belonged in Virginia, where the mine was. Dismissed. So, he sued in Virginia. That court dismissed it too, saying he had already had his day in court. In 2013, the Supreme Court of Virginia disagreed and revived the case. In 2014, 16 years after the mine closed, a Virginia jury finally awarded damages. $5 million against an original $50. That January, the judge threw out the damages award and ordered a new trial on the amount. In 2017, that retrial was still running. Caperton was still testifying, 19 years after his mine closed. And there the public record goes quiet. I could not find a reliable source for how it ended, so I am not going to invent one. Brent Benjamin stayed on the court until 2016, when he lost his seat at the ballot box. Don Blankenship was later convicted of a misdemeanor, conspiring to violate mine safety standards, and served a year. He was acquitted of the 2 felony charges he faced. So, can you ask for a different judge? Yes, anyone can ask. You file a motion asking the judge to recuse himself. But almost none of those motions are decided by the Constitution. They are decided by state rules and by statutes. In federal court, the standard is a single sentence. A judge shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. The Constitution sits underneath all of it as a floor, not a ceiling. It marks only the outer boundaries. States remain free to demand more. Some already did. Which is why Caperton is not a tool you reach for. It is the fence at the far edge of the field, confined to rare instances in the court's own words. Whether it stayed that rare, nobody has actually measured. Roberts predicted a flood. Scalia predicted a new weapon for lawyers. That argument is not settled. And most of the time, when you ask for a different judge, the person who decides is the judge you are asking about. That is not a loophole. That is the system working exactly as designed. Whether that is good enough is the part we are still arguing about.